Greetings, this is Chapter 9, and the topic is sexual harassment. Now, sexual harassment is a subset of gender or sex discrimination, but it is a unique area in and of itself, really deserving of an entire chapter. I normally wouldn't have included 5 chapters in this module, but since sex discrimination and sexual harassment are so similar in terms of some of the boundaries and some of the rules, that I thought it was appropriate for me to include it in Module 2, Module 3, including 4 different lectures, and then the last module will be 3. It'll be a little bit lighter. But this chapter really gets at how sexual harassment is a subset of sex discrimination and the different contexts and situations in which sexual harassment can occur. There are 8 learning objectives for this chapter. Number 1, we're going to recognize the background leading up to sexual harassment as a workplace issue. So understanding some of the history, understanding some of the issues around the legislation, knowing what is considered to be harassment and what is not, and why this was a relevant issue for us. Explain quid pro quo sexual harassment and give the requirements for making a prima facie case. We also are going to learn about hostile working environment sexual harassment and what the requirements are for making a prima facie case of that. They are very different. So be aware that the criteria for quid pro quo is not the same as the criteria for hostile working environment. Number 4, list and explain employer defenses to sexual harassment crimes. And so the employer, like in any sort of situation where they're charged with discrimination, has a list of defenses that they can make available to them. Learning objective number 5, define the reasonable victim standard and how and why it is used in sexual harassment cases. Basically, we use the reasonable woman standard or the reasonable victim standard because not all harassment is necessarily about what women experience. Oftentimes men are victims of sexual harassment. So what we're trying to do is really understand if you're in that circumstance, what would be the reasonable conclusion that one would draw for the individual who is being harassed. Just because another man might not feel it as harassing doesn't mean a woman or the victim in this circumstance, whoever that might be, might not feel that harassment. We want to differentiate the sex requirements and anti-female animus in sexual harassment actions. We want to talk about explaining the liability for various sexual harassment claims. Employer liability is big, and it is important that employers make sure that their workforce is not perpetuating sexual harassment. Lastly, we want to describe proactive and corrective actions an employer can take to prevent or lessen liability. Obviously, that's the goal of this course, right, is to make sure that we understand how we can prevent these problems from happening in the first place. There are both statutory and regulatory bases for determining sexual harassment discrimination. Number 1 is in the Title 7 of the Civil Rights Act, amended, and it says it is unlawful for an employer to fail or refuse to hire or to discharge any individual or otherwise to discriminate against any individual with respect to compensation, terms, conditions, and privileges of employment because of an individual's sex or gender. Now that sounds just exactly like the sex discrimination or gender discrimination, and you're right, it is, because as I said, sexual harassment is a subset of gender discrimination, but it is so pervasive and is such a big issue that it has its own chapter in this book. Number 2, the unwelcome sexual advances, requests for sexual favors, and other verbal or physical conduct of a sexual nature constitutes sexual harassment when, number 1, submission to such conduct is either made explicit or implicitly a term or a condition of their employment, that submission to or rejection of such conduct by an individual is used as the basis for employment decisions affecting these individuals, and such conduct has the purpose or effect of unreasonably interfering with an individual's work performance or creating an intimidating, hostile, or offensive working environment. And this comes from the EEOC's guidelines to try to address with more clarity what it means, how sex discrimination or gender discrimination applies to the form of sexual harassment. So while it is based in Title VII. It is the guidelines provided by EEOC, the regulation that's set up that gave employers more clarity. But this didn't happen until probably almost 20 years after the initial legislation passed. And again, it's complex because, as I told you, the sex discrimination or gender discrimination wasn't initially included in the legislation. It was added at the last minute, so it didn't have these administrative guidelines and regulations set up and in place and thought through with some detail about what they meant and what was going to be considered harassment or not, or what was discrimination or not. And it never occurred to people that sex discrimination would include harassment. Largely, people don't like to talk about sexual harassment or particularly about when they have been sexually harassed. But we're seeing a huge trend these days with the Me Too movement, where women are more likely and more willing to step up and say, not only was that person harassed, but I was as well. One of the reasons why women don't report sexual harassment is because people don't take them seriously and they become the person on trial. And this is the same thing for rape cases, but that's out of the scope of this class, right? But women specifically, when they have spoken up and have said, I'm being harassed, this is inappropriate, the tables are always turned, or usually turned, not always, but usually turned on the women, and they are the ones put on trial. They're not believed, they're not taken seriously. And so women have gotten to a point where they're not very much interested in continuing to fight a battle with somebody who doesn't want to listen to them. So I think that's part of the big changes that we need to make as a country, but certainly in organizations, is we need to take every complaint seriously. And then we need to not assume that the woman is guilty in those circumstances, or that the woman was somehow complicit, um, because we tend to not take women as seriously when they speak up about their harassment claims. So what we do know, right, is that opportunities are lost for people who are victims, that it has a decrease in organizational productivity when women are struggling with sexual misconduct and sexual harassment in the workplace. They feel like they can't advance, they can't move out of the situation that they're in, and because it overwhelms their cognition, it makes it really difficult. There's a huge cognitive load and an emotional load that goes along with when you are dealing with a sexual harassment case. I've been harassed myself. I was an MBA student, and one of the professors had harassed me, and I understand how that all plays itself out. I had several charges against this guy in order to get out of my undergraduate program without him continually my master's program without him continually harassing me. So, if court organization doesn't manage their sexual harassment problem culture in the organization, we're going to end up with more expenses to defend ourselves, the damages that are going to happen, financial damages that are going to be placed on the organization, that it becomes a distraction to managers to have to deal with these issues and the morale that goes along with it. And it has a negative impact on people's lives tremendously. I mean, it dragged on me for a long period of time. It was several years of just dealing with the constant barrage of crap from this guy, and it was not easy to do. So I think it is important that as we deal with this at the organizational level, that we manage the culture so that the culture does not support sexual harassment, that we have workplace policies that do not support sexual harassment, and we really make sure that we listen to women when they complain about harassment issues. And this slide really just underscores some of the things I spoke to previously, that women aren't taken seriously. And the maltreatment of women in the workplace goes back centuries, whether that was slaves in the slave fields that were being raped by their masters or their supervisors, or in the textile mills where they were told if they didn't comply with sexual favors that they wouldn't be able to keep their job. So it is frustrating that here we are in 2021 and sexual harassment is still a relevant issue when it should have been eliminated years ago. As I said, harassment is a subset of discrimination based on gender. and sexual harassment is. And the Supreme Court, as I told you, didn't even hear the first harassment case till 1986. So it's been a long time coming for us to really understand, that harassment, sexual harassment, is a form of sex discrimination. It's 22 years from when the legislation passed. Why did it take that long, right? The Anita Hill 1991 testimony against Clarence Thomas was a prime example of a watershed moment in our history. And it was certainly watershed for me when I heard that case, because of the fact that I had been sexually harassed. This is around the time that I was sexually harassed by the MBA professor in my program. And it really empowered me to speak up and share me too, that I had been harassed and by this guy, and this was not okay behaviors. And so the whole thing with Clarence Thomas and Anita Hill, she testified that he had engaged in harassing behaviors while Thomas was the head of the EEOC, which is kind of stunning when you think about it, because he, should have appropriately known better than to engage in those behaviors. And Anita Hill was his assistant, at the EEOC. It affected the workplace environment. It led to all sorts to increased in claims in the EEOC. I did some research on this, and we found a massive increase in complaints filed by the EEOC after that hearing, as well as the tailhook incident, which occurred, which we won't get into probably in this class, but the tailhook happened with the Navy pilots. And they would constantly harass women officers in the military. So this was a military-related issue. But both of those events sort of came up in the presence of people's minds in 1991, 1992, and therefore really compelled people to pay more attention to the issue of sexual harassment. So this was really a tremendous issue for the march against sexual harassment and the march towards including it as a form of sex discrimination. It gave it much more legitimacy when it was in the public eye. So over the history, we can see 1996, now it's about 5 years after the Anita Hill Clarence Thomas hearings, and there was a multi-million-dollar award versus a law firm that ignored chronic problems with sexual harassment. And so it came down to it that if there was going to be a problem and the organization was going to allow systemic sexual harassment to occur in its company's culture, there were going to be financial consequences for those companies, and the companies themselves are going to be held liable for those behaviors, which was really important. In 1998, Supreme Court rules on the Ellerth and the Farragher cases that really started to nip harassment in the bud through all sorts of policies and reportings. And so in the 98, we started to see many more requirements on sexual harassment policies. There are still issues because the Me Too movement has arisen in the last few years that says, people are still systematically and systemically harassing women, even if it's in the entertainment field, as we saw with so many women in Hollywood complaining about the harassment they got to be able to make movies and to do their art in Hollywood. And so it's really challenging still for women to be taken seriously. Allegations of sexual misconduct arose again for a Supreme Court candidate when Kavanaugh. There were several women who accused Kavanaugh of being sexually harassing them and sexually assaulting them when they were in college and law school with him. So it's strange, that, people get into power, but we don't take women seriously when they complain about these things. It's very frustrating for me personally, but I know, sort of from as an academic and someone who is trying to teach this stuff, it's so challenging for me. I don't know how to get it through to people, that treating people sexually in the workplace is just not acceptable. So how big of a deal is sexual harassment? Well, I mean, I think I've sort of made the case, but obviously there is a lot more data that shows that this is really an issue. The U.S. Merit Systems Protection Board did a study on harassment and found that 42% of federal employees working for our federal government reported sexual harassment in both 1980 and 1987, two separate surveys. More studies by Working Women and New York Times, National Law Journal, Parade, all of them say between 40 and 70% of women have been harassed in different work contexts. And class action claims are emerging. They were rare years ago, but now we're seeing much more likelihood of a class action suit occurring perhaps across industries. So it'll be very interesting to see how that plays itself out. So if sexual harassment is an important consideration for employers, where do they put boundary conditions around relationships and consensual relationships? And to be clear, consensual relationships are not forbidden. As long as two parties agree to have a relationship, even if they're in a power differential, that has to be reported and documented when it begins and when it ends. I mean, that's a really good policy. Exhibit 9.2 has some great examples of model sexual harassment policy, but you can have a consensual relationship with someone even if there's a power difference. It's usually discouraged, but it's certainly possible. I mean, and think about this, folks, right? We spend most of our waking hours on the job. It's not uncommon or unlikely that we're going to meet the person that we would love to date or marry while we're working on the job. I've seen this happen in many organizations that I've worked in, where couples met on the job and they, that sparked a connection and off they went. And it wasn't always necessarily harassment in that situation. So consent is a dynamic variable. Consent is not something that I can say I've given my consent and then I'm consented forever. I can consent now and then I can say, no, this is not a consensual relationship anymore. But we have to be clear when that changes, and that has to be reported to your employer to protect you and to protect the employer. The company risks increase dramatically if one participant does supervise the other. As I said, it's not illegal to have a relationship like that. It's illegal to harass somebody in a power differential, but it's not illegal to have a consensual relationship, right? It becomes problematic when actions directed toward the employee become unwelcome, which is why when we talk about consent as a dynamic variable, what it really means is I can decide tomorrow I no longer want this attention. I no longer want to date you. And that becomes now any attention you give me after that fact is considered unwelcome. So it is important that we communicate with our supervisors, with HR, with superiors when our relationship ends so that we're very clear when consensual ends and harassment begins. Several states now actually mandate regular supervisor general employee training. The state of Illinois is one. As long as you have one employee, you are required in the state of Illinois to make sure that we have regular sexual harassment training.